Zahvaljujem, poštovani sud.
Thank you, Your Honor. Before the break, I said that the evidence adduced did not demonstrate that these individuals, officers of the VRS and SVK, who were, according to what the OTP states, because of the 30th and 40th personnel centers, were members of the VJ. Let me continue along the same lines, but from a different angle. In order to link these officers up with the VJ, the prosecution looks to evidence on formal orders appointing them to duties within the personnel centers. According to the prosecution, if they are appointed to a duty within the personnel center, and the center is a body attached to the VJ General Staff, then by the same token, they are within the line of, within the chain of command of the VJ, and therefore subordinated de jure to Perišić. Even if they were not within the VJ before, as these orders were passed, they would become, in institutional terms, members of the VJ. You will have to assess these positions within the evidence in its entirety. The prosecution is well aware of the fact that these orders were only formal paperwork enabling these individuals to claim status rights and nothing more. The prosecution knows that if the matters were as lege artis as they would wish them to appear, in that case, there would not have been any need to set up these personnel centers. The prosecution knows that the top state leadership would, in that case, not be concerned as to whether the orders would be executed or whether the matter would be taken to court. The prosecution is aware of all this because in their submissions they chose to rely on the evidence speaking to these matters. The prosecution evidence demonstrates that these appointment orders into the personnel centers were not accurate, among other things, in their substance, in terms of the information that they contained about the actual existence of these units within the VJ, as nominally indicated in these documents, and in terms of the actual establishment post which purportedly existed within the VJ and to which these officers were appointed. In paragraph 150 of their brief, the prosecution refers to Perišić's words as reflected in P709, which is minutes from a meeting, the 14th meeting of the SDC, I believe. And let's have a look at what it is that the prosecution have to say. Let's look at page 32, if we could have it on our screens, of P709. This is the 14th minutes in 1993, when personnel centers were discussed for the first time, and this is the portion quoted by the OTP in their brief. I will only be quoting one essential sentence. In order to avoid receiving any complaints from anyone, we invented a temporary formation within the Army of Yugoslavia. We will be appointing them here, but in actual fact, they are not here. Rather, they are in the areas to which they are posted. In other words, Your Honours, a temporary formation is invented. They are not here. Rather, they are in the other place where they actually are, which is the VRS or the SVK, holding duties which exist in reality and to which they were appointed pursuant to orders issued by commanding officers of those armies. On the same page, page 33 in English, there is a reference to Perišić's words yet again. And Perišić goes on to explain the mechanism envisaged behind this construct. And this is what the OTP quotes. In the orders, we will be, for instance, writing to them, the commander of such and such a unit shall be deployed in a training corps, which is supposed to be here, but in fact, he's going over there. Hence, a unit which is supposedly here is a reference to the Army of Yugoslavia, and the units over there, where the individual actually is a reference to the VRS. And this is precisely how, when assessing P734, instructions governing the work of personnel centers, which is something that both sides are referring to, and specifically paragraph 25 of the instructions that we are referring to in our final brief, you will see that the procedure was defined in detail, as referred in our trial brief. So why is the defense insisting on the actual state of matters when speaking about transfers and appointments to duty? And this is something that we discussed in detail in our brief at paragraphs 272 to 295.
Your Honours, we are talking about armies here and the functioning of these armies. Appointment to a duty in any army establishes relationships within the service involved, and that is a relationship of subordination and superiority. One becomes part of a single chain of command. Every member of that army, including the officers that we are dealing with here, gets his or her superior officer. And now this is what matters to me. The orders of that individual have to be obeyed. And not observing these orders produces consequences. They have to be held responsible. That is how any army functions, and that is how the VRS and the VJ functioned. Therefore, Your Honours, because of these principles, you have to study in detail all the evidence that speaks of such appointments. Both parties have presented such evidence to you. And it is only then, on the basis of assessing all of that evidence together, rather than partially, you will come to your conclusions about which army a particular officer actually belonged to when being appointed to a certain duty. In the VRS, these orders on appointment functioned fully, with truthful contents, completely. And if one does not act in accordance with such an order, the mechanism did function within the Army of Republika Srpska. In the orders of the 30th and 40th Personnel Corps, that is not the way appointments took place. I'm going to give you an example now showing what an actual order on appointment is and what a fictitious one is from the point of view of this situation of superiority and subordination. When the prosecutor develops his thesis on appointments, invokes the so-called group orders on transfers and appointments. So I would like us to deal with a particular case that can be shown through some of their exhibits that they spoke of themselves, 2128. It has to do with Mr. Tolimir, General Tolimir, because that is what they actually analyze in their final brief. They analyze it in paragraph 175 of their final brief. And this is what they say. That is the only order that they invoke. That Tolimir, on the 7th of February 1994, was transferred to the 30th Personnel Center of the VJ, and that this order made formal his service that had started on the 10th of November 1993. By now, I believe that all of us in this courtroom are familiar enough with the fact that the 10th of November 1993 was the day when personnel centers were established on the basis of an order issued by President Lilić. Before we look at that document, I suggest that we...
Slow down. I heard that the interpreter rushing desperately to keep pace with you. Slow down.
Ja bih sad ipak zamolio da idemo hronološki.
Please let us deal with this chronologically. So before we look at this document, let us look at something else. But we will be looking at this eventually as well. Let us first look at Defense Exhibit D693.
Akt je u pitanju predsjednika Republike.
This is a document issued by the President of Republika Srpska. The date is the 16th of December, 1992. Then Colonel Zdravko Tolimir is being appointed to Assistant Commander for Intelligence and Security in the main staff of the Army of Republika Srpska. You can see that previously he, as it says here up until now, it says that a bit further down, he was Chief of Administration for Security in the main staff from the 10th of June 1992. Now let us look at another document before we go back to the prosecution document that I referred to. That is D526.
Nakon završetka rata, 20.
After the end of the war, on the 28th of January 1997, this is a document of the President of Republika Srpska because it is only decrees, presidential decrees, that deal with appointments of generals. General Tolimir is being relieved of his hitherto duties, and you see here which duty he held, the one that we saw a moment ago, from December 1992 onwards. Assistant Commander for Intelligence and Security Affairs in the main staff of the Army of Republika Srpska. Let me digress. Even the prosecution themselves accept this title of Mr. Tolimir's as a real one, because throughout their brief they accept that Tolimir held this position that we've read out just now. That is paragraph 175, 197, 539, even Annex G of the prosecution final brief.
Sada.
Now, when we have this picture, let us look at P2128. This order of the General Staff of the Army of Yugoslavia, BCS page 3 and 4, and English page 3 and 4.
Malo niže dole, Tolimir, donji del.
A bit further down in BCS, Tolimir. That's where it starts, and then it continues on the next page. Now, could I have the next page in English, please?
Ovaj dokument, inače, na stanici koji
The date of this document is the one that the prosecution refers to, and that is February 1994. Now, let us see what this document says. It says that on the 7th of February 1994, he is appointed in the General Staff of the Army of Yugoslavia as Assistant Chief in the 30th Personnel Center in the main staff, and the date is the one that you recall that witness Momčilo explained to us, I think. 10/11/93, that is the date, the 10th of November 1993.
I navodi se, pogledajte malo niže dole da...
A bit further down in the text, you see that up until that date, the 10th of November 1993, he held a position in the 2nd Military District, holding the rank of colonel, from the 30th of August 1990 in Sarajevo. Both of these pieces of information are incorrect, Your Honors. You saw a great deal of evidence regarding the structure of the General Staff of the Army of Yugoslavia in all stages of the indictment, before Perišić and after he was appointed Chief of General Staff. Remember those organizational diagrams, D195, D196, D197, D198. According to the establishment of the Army of Yugoslavia, there was no main staff. There were no corps either, except for the Special Units Corps of the Army of Yugoslavia. That was the only corps that was subordinated directly to the Chief of General Staff. But there are no brigades or corps that are within the General Staff of the Army of Yugoslavia. You saw the diagrams. There is no such thing. Another piece of information that is incorrect is as follows.
What is meant, now that you're talking about corps in the region, what is meant by the term First Army, Second Army within the VJ vocabulary?
Armije su bile, sad ja bi trebao da budem stručan.
Now I would have to be an expert in the field, and I'm not. Armies were the highest military units that covered a certain part of the territory of Yugoslavia, and they had their respective areas of responsibility. These areas of responsibility and these units were outside the General Staff, but the structure, in terms of the structure, they belong to the General Staff too. Let me explain this immediately. I think that at the time when General Perišić headed the Army of Yugoslavia, I think there were 3 armies.
Svaka od 3 armija.
Every one of these armies covered a certain territory. In the days of the JNA, I think there were 5 military districts that later turned into armies. and they covered a certain territory, so they were above the core level in this territorial organizational structure. That's where the army is. The army is superior. I mean, it is a group of corps that cover a certain territory.
Just told us there were no corps in that time. So
Yes.
in the place of the corps, there was the army, the first army, the second army, and all these various armies were part of either the JNA or the VJ.
That's right.
So
Yes.
in fact,
Ja
are we to understand that in substance, the first army is the same thing as a corps, but probably big.
No.
Tako je, veće. Tako.
That's right. Bigger. Exactly.
Dakle, drugi podatak koji je netačan,
Another piece of information that is incorrect in this document is that Mr. Tolimir was in the 2nd Military District from the 8th of February 1992, and then, as it says here in this document, until the 10th of November 1993. Why? Because the 2nd Military District, after the JNA fell apart, no longer existed. The 2nd Military District was within the structure of the old JNA. And in that structure, or he could have been in that structure only until May 1992. So in this period of time, that could not have been the case. And that is what this document states, and that is incorrect.
još jedan primjer i neću više.
Another example. And I'm not going to explain it any further, but I want to show through these examples how, in my view, this evidence can be interpreted in the easiest way. As a lawyer, I found them very difficult to understand and interpret. P1732, can we please deal with that now? We don't have to put it on our screens, but it's very similar. That is a prosecution exhibit by which they wish to show that Vinko Pandurović was a member of the Army of Yugoslavia from the 10th of November 1993. It's the same type of order like the other one.
Evo.
Here it is. Thank you. Perhaps it's going to be easier for us to follow if we have it on our screens.
Naredba je 7. juni 90.
The 7th of June 1994 is the date of this order. It was issued by the General Staff of the Army of Yugoslavia, which we are not contesting. And it says that then Major Vinko Pandurović in June 1994 is being assigned to, look at this name of the unit, General Staff of the Army of Yugoslavia, the 30th Personnel Center, Ground Forces Corps, Light Infantry Brigade. Incorrect, Your Honors. All of us in this courtroom know that. There was no such thing in the establishment in the General Staff of the Army of Yugoslavia. We saw evidence to that effect. And look at what it says further down. Again, something incorrect, that up until the moment when this decision was made, he was relieved of duty and sent for training to the General Staff Academy already in October 1990. So according to this document, it seems that he is being trained, that he is undergoing schooling from October 1990 until December 1993. And we know that that was not the case. The prosecution knows that too. There's plenty of evidence to show that. He was in the Army of Republika Srpska. Could we please have D296 on our screens now?
Ista vrsta akta, postavljanje.
The same type of document, appointment, but a different state. Republika Srpska, according to their law of the 8th of October 1993. The Minister of Defense is appointing Vinko Pandorovic commander of the 1st Zvornik Light Infantry Brigade in the Drina Corps.
I to je stvarna dužnost na koju je on bio?
That is the actual duty that he held, and that is what Mr. Harman refers to as well. In the indictment, in Schedule E of the indictment, in the annex of his final brief, in paragraphs of the brief itself, 406, 421, and 438. That was the position he held. That was the actual position he held.
Mi vam tvrdimo, poštovani sude, da u svim...
We are telling you, Your Honors, that in all these decisions, group orders concerning appointment, the only true information is the one entered there, and that pertains to rank and position. And you heard a great deal of evidence about certain status rights that have to do with salaries, benefits that accompany a particular status, and that is the only thing that caused legal effect, but not the way the prosecution is trying to portray it, that through these orders they entered the chain of command of the Army of Yugoslavia.
Jer osim u odnosu na...
Because other than where it concerns salaries, these orders would have had no other legal effects. But I will come to that later. But even when it comes to salaries, nothing in these orders alters anything that was the situation before that. And you had evidence to that effect. Now, where then can we find this significant contribution of General Perišić to the personnel centers in providing officer cadres for VRS? Now, that these orders did not establish the most important thing in any letter of appointment, and that is the subordination or chain of command, I will show, Your Honor, the chain of command that the prosecutor is trying to show in their Annex C of the final brief, where they say personnel centers are part of the personnel administration of the Yugoslav Army, and the personnel administration is part of the sector for mobilization and structural changes of the General Staff of Yugoslavia, and that sector was actually subordinated to General Perišić as the Chief of Staff of the General Staff of the Yugoslav Army. Now, if that was the case, Your Honor, I wonder, and I would like you to consider this in coming to your conclusions, would this mean that General Mladić was subordinated to Zorić, who was the chief of the personnel administration, or, for instance, that he was subordinated to General Matović, who was the chief of the sector for mobilization and development of the General Staff of the Yugoslav Army? Is it possible that Mladić was subordinated to them, and this is what the prosecution's claim is? Would it be the case that Mladić would actually abide by anything that this person said to them? And this is the chain of command that the prosecution is trying to show existed there, and that the prosecution is trying to claim that it was an attempt to institutionalize the membership of these individuals in the command chain or chain of command of the Yugoslav Army.
As I understood Mr. Harman's argument yesterday, and I think this was also alluded to sometime during the trial, the prosecution postulates parallel chains of command. I heard Mr. Guy Smith yesterday contradicting that and saying, no, there can only be one chain of command. So basing it on the prosecution's theory without necessarily accepting it, is it not possible, therefore, that operationally Mladic wouldn't take commands from the chief of the administration for personnel in the personnel center, but that administratively that chief dealt with Mladic's salaries, whatever, or not salaries, but submitted reports to the paying office of his rank, his position, his service, and therefore what he's entitled to as a salary.
Ja ću kasnije da pričam.
I will speak about the parallel chain of command a little later, but your question is very to the point, and let me say a few words about it. What you have asked me, and by the very fact that you've put this question, you are actually seeking to find the verbal expression for how these matters are institutionalized. And that is indeed the case, but that at the same time is not the chain of command. The chain of command means issuing and following orders. And that is something that Matović could not do, nor anything else that had to do with any administrative matters. General Matović could not issue orders to General Mladic. For instance, he could tell Mladic, and this is an administrative matter, I need a report about the situation with your family, so would you go to your service there and provide that information for me? Now, this is what the prosecution is claiming, that they could issue commands because they could also issue administrative orders. But the chain of command and control means only one thing. And in my view, this is the red herring that the prosecutor, Mr. Harman, is trying to show us here, where he's equating these two. We can talk about that, but in fact, that is not the case in the case that you have before you. This is just a red herring. It's just conflating two different things. Now, I will come back to that later when I speak of command responsibility, and perhaps then you will have more questions that would clarify that matter. May I continue?
You may, Mr. Lukic.
Kad budete na kraju...
Your Honors, when you have to draw your conclusions on one of the crucial matters in this case, according to the defense, which is whether these officers that were mentioned in these group orders, that's how I would refer to them, whether thereby their position in the Yugoslav army was institutionalized formally, I ask you to ask yourselves the following, and the Honorable Judge David put that question at one point on transcript page A340 and A341 to one of the witnesses, where he asked the following: did the paperwork show one thing and in reality the facts were different? Perhaps this question was actually directed at something else, but this is very important for our case here, because the evidence that we have before this court about the actual reality are actually based on fictitious thesis of the prosecution. Now, the fictitiousness can be seen in another important argument of the prosecution, which relates to command responsibility and effective control. The prosecution is trying to show that these orders actually indicate that there was effective control, and they mention this in their paragraphs 782 and 783 in their final brief. However, it is the defense position that it is, in fact, these very orders that show that there was no effective control. These orders that the prosecution in paragraph 783 claims were binding, in reality, were not orders to which responsibility would be attached, such as any orders which are not obeyed, which relate to military orders. And witness Starčević spoke about this on transcript page 5571. And why is this so? Well, because it did not actually correspond to reality. First of all, these individuals were in the VRS, and if they disobeyed those orders, there would be no responsibility and no consequences. That's number one. And number two, where the orders were, where individuals were assigned subsequently, they could only be transferred to those other armies if they agreed to that. Now, this is not something that you will find in any law as a precondition for obeying orders. And why is this so? Because it had to do with transfers that were not regulated under the law. And all of the participants here are aware of that. Had these orders really been binding, there would be no voluntariness and no attempts by anyone to try to talk someone into going anywhere, including by General Perišić. I would now like briefly to digress and mention another argument by the prosecution that has to do with the assignment to posts. And it is our position that the prosecution did not show beyond reasonable doubt that Perišić did have the authority to appoint within the VRS itself. And this is what they claim in their final brief, and I believe they also mentioned it in their closing arguments. The evidence shows that all, and I repeat, all appointments to certain positions in the VRS and the SVK were done exclusively within those chains of command without any involvement by anyone from the Yugoslav army or by General Perišić himself. In order to corroborate their position, the prosecution in paragraph 183 of their final brief refers to analysis of evidence P2126 and P1815 in isolation. Those orders that the prosecution makes a reference to is nothing other than the appointments of these individuals to their posts or changes in their establishment post. On the other hand, defense witnesses and prosecution witnesses as well, Rašeta, Orlić, Škrbić, Malčić, Novaković, and I will mention no others, although there are more, testified here that all appointments to duty were done exclusively within the systems of those two armies, the VRS and the SVK. We provided our references in our final brief in paragraphs 280 and 280 to 301. In other words, both prosecution witnesses and defense witnesses tell the same story. Now, in relation to those facts and the witness that I just referred to, the prosecution never in their cross-examination asked any of the defense witnesses to clarify any of those theses. As for the prosecution witnesses, Rašeta and Orlić, whom we cross-examined, the prosecution had nothing to ask them in redirect. In other words, they are not really contesting our position, and the prosecution completely ignores this. It just goes over it. Now, the prosecution also claims that General Perišić forced officers who refused to go to VRS or SVK to go, and if not, that he actually punished them, as claimed in paragraph 184 of the prosecution final brief. In this paragraph, they refer to certain exhibits, such as, for instance, P1865, which is an order from the 3rd Army after a meeting with officers from the SVK, where there's a discussion as to who is going to be retired and who is going to be assigned to the personnel centers. Now, this exhibit, when shown to witness Škrbić, actually prompted the Honorable Judge Molotov on transcript page 11895 to ask for clarification as to what the substance truly of that document was. Obviously, exhibits such as these cannot prove beyond reasonable doubt that there was coercion on these officers. The prosecution did not show any witnesses who would speak about these decisions, nor that they would be coerced into retirement if they refuse to go to the VRS or the SVK. So there is no evidence, either direct or indirect, that would lead beyond reasonable doubt to the conclusion that any individual was retired as a direct consequence of their refusal to be assigned to the VRS, as the prosecution claims. Our colleagues from the prosecution also referred to the Erak case, and Mr. Harman referred to it by the same name, which is mentioned in paragraph 189 of their final brief. The written evidence that the prosecution is producing here in order to show coercion actually do not prove that there is any coercion. If you look at the notes from a meeting, and this is in document P1896, a meeting, notes from a meeting between Erak and his commander Živanović, where he says, well, let's wait for the document to come up on the screen. That's P1896.